Oh my gosh. Oh Lord, if y'all can see me, I'm laughing. I'm laughing because this is, I need one of them little things they use in uh in the movies. Take one, take two, take three, take four, take five, take six. I think I'm on about take seven. Y'all ready? Let's go. Okay, so the letters from Morrissey and Lowley and all that that went to the to the Department of Justice trying to get trying to get the FBI to back off their case. The interesting thing is they don't share this stuff with people, but yet they shared it with the defense. So why would they do that? Well, let me just say that I think that, well, I'm sure they shared it with the defense and they shared it with the prosecutor. And what they were trying to say is, we're not going to back off. We're not going to back off. There's an issue here. And we're not going to back off. But the interesting thing is, if you're supposed to be the seeker of truth, the finder of facts, and you've got all this stuff that you're looking at and that you're seeing, Beverly, I guess they do let imbeciles and idiots become judges because there's so much that you didn't let in that really is relevant to this case. And if you're the only deciding factor on what is and what is not relevant, I think you need to uh, maybe you should take a week off and go to the Cape. And you might also want to put in your resignation papers. You started off as an attorney. I don't know what it was you were expecting, but where you are now, where you're sitting there and you're saying, I'm the keeper of the records, I'm the judger of facts, I'm the one that controls this, I control that. Well, by golly, when I'm sitting here as just a regular person who one day could end up on a regular jury, and I hear a judge sitting here not allowing pertinent information into this trial, I got a question. What's your problem? Evidence that would help back up the defendant. You see, you don't want Karen Reed to have justice. You want her railroaded. I'm not quite sure why. But with that being said, I found the video. Yeah, I'm behind a lot of people, so yeah. But I found the video and I'm going to share it. I hope y'all enjoy it. Um, I'm going to say I hope y'all hadn't found it, but this stupid protective order where they're trying to get the FBI out of their hair and not allow any of this stuff to come out to the public. It's a bit much, Lally. And Beverly, it's embarrassing that you don't care more. So now that I've said that, let's just see what we can do about getting this video up for you. We're going to share the screen. And that's going to be this one. And we're going to hit share. We're going to go on right in there. We're going to do this right here and hope it works.
Remedy of keeping those letters hidden from the public is warranted. The court must first consider the content of those letters. And in order for me to be able to argue against this motion for a protective order, I must.
So just so it's clear, I have not seen those letters.
Okay. I still, Your Honor, I must discuss the content of those letters to some degree and argue to this court why a protective order makes no sense in this case. And with your permission, I'd like to divide my argument on this issue into two parts.
I'm really sorry. I have to speed it up, I believe. I mean, I think that you're not allowed to play at regular speed. I don't know. I don't know enough about what I am and am not allowed to do. But the funny thing is, this motion is brought by the Commonwealth. And she's such a witch. Replace the W with a B because that's how I feel. My apologies for my personal opinion.
First, I will argue to the court that the Commonwealth has not met the legal standard necessary for the issuance of a protective order. And second, I will argue to the court that a protective order will accomplish nothing in this case. Because the
Exactly.
All right,
content,
so which part do you need to reference the letters? Because I'm going to need to read them before you reference them.
so with regard to the first part, which is that the Commonwealth has not met the legal standard, the only way to discuss whether they've met the legal standard is to know what the letters are. And just
Right. So I need them. I don't have them, and so you
I
would
need
be
them. Why
arguing the
didn't you
content of
ask
the letters in
Lally?
the first part. All right. How about the second part of your argument? Would you be arguing them as well? Nobody provided them to me.
Oh, why don't you ask Lally where they are,
well,
sugar?
this is the Commonwealth's motion, Your Honor.
Yeah. And your opposition, and I don't have from anyone.
And your
So
opposition, and I don't
how
have
about
it
the
from
second
anybody.
part of
So
your
it's your
argument, Ms.
fault.
Giannetti?
It's you.
Well, it does
Lally
touch
can
on
do
that,
what he
Judge.
wants.
You know, the Commonwealth has revealed some of the contents of some of the letters, but I need to point out what they haven't revealed. You know, and just so it's clear, I'm not going to be quoting the letters at length. I'm going to be talking about the subject matter of the letters. In my view, I don't know that the court needs to read the letters first, but I'll leave that to Your Honor.
All right, but you said you're going to reference them, and the whole motion concerns those letters. Do you have them, Mr. Lally? Do you have them with you?
Yes, Your Honor.
Oh, now we ask Lally, right? I would think he should have
If you're
filed
just
it
going
with his
to, in
motion.
general terms, just give me a couple minutes now to just look through them, Ms. Giannetti.
That's fine, Your Honor.
Thank you.
That big man on campus didn't bother to file it with it, huh? She was going to jump on Yannetti. With Lally, it's just like, oh, do you have them? Can I have them, please? I mean, lady, everybody sees your behavior.
The 18th letter.
Letter that I'm
Sorry about that. I need to learn to
Ms.
fast forward.
Giannetti, so far there's one letter that I'm going to need more time on. It's a letter dated May 18th, 2023. The others so far, I'm prepared to let you argue in general terms.
With regard to that May 18th letter, Your Honor, that is not one that I will be quoting.
Okay, that's why I brought it up.
Right.
Okay, so
Why I responded.
And I don't believe I've seen the May 18th one. I could be wrong because I'm just going by memory. And Lord, y'all know my memory. So let's just, I might have. If y'all watch.
so you also not going to reference the response to that letter? June 1st?
Correct. Yes. Yeah, those deal with the Office of Professional Responsibility. That was
Okay, I just have two more to just quickly take a look at.
Sure.
Does she do any of it quickly? I mean, she just really likes having her time. Look at poor Karen up there. Her face is red. She's got to be, I mean, she's got to be just livid. Just livid. But you know, everybody from watching the trial, we all know how she acts. I hate the fact that this cuts half her face off. Well, I don't really care because I don't like seeing her. But her smirks and her attitude, you know, they just should have shown more of it. Because she's just so, she's, let me try again here.
Do, Your Honor.
So the letter
Oh, sorry.
So the letter dated August 3rd, 2023. You have that in front of you, Ms. Giannetti?
Do, Your Honor.
All right, so the second paragraph, the second full paragraph, I'm not going to allow you to reference that right now.
Your Honor, if I may, the letter may be visible on the Zoom screen.
I've got the,
Just when you're holding it, you can see it.
see the light can see through it? Because I've got the print
Oh
facing
my
me.
You can see a
goodness.
portion of the print, that's all, from the angle.
All right,
Heavens.
thank you.
Oh,
All right, so with that,
oh,
with those parameters, Ms. Giannetti,
mercy.
I will let you reference the subject matter of the others.
Okay,
FBI
that's
doesn't
fine, Your
care
Honor.
if it's shared, but she cares
So
for he
in terms of the two parts of my argument, I will first argue that the Commonwealth has not met the legal standard that is necessary for the issuance of a protective order. The second part, I will argue to the court that a protective order will accomplish nothing in this case because the contents of those letters will be revealed in full during oral argument before the public on the motion for sanctions that we filed immediately after our last court appearance. So first, Your Honor, I urge this court to deny the Commonwealth's motion for a protective order because they have not met the necessary legal standard. In their motion, the Commonwealth cited Mass General Laws, Chapter 4 and 27D, which stands for the proposition that interagency memoranda or letters relating to policy positions being developed by an agency should not be considered public records. An agency's discussion of policy positions is akin to an attorney's discussion of trial strategy. It's not work, it's work product, it's not discoverable, and it's not a public record. But that is not what we have here. The 8 letters that have been provided do not discuss at all policy positions being developed by any agency. To the contrary, these letters fall into 3 categories. Category 1 are 3 letters consisting of a back and forth between the Norfolk County District Attorney's Office and the U.S. Attorney's Office for the District of Massachusetts regarding whether the U.S. Attorney would release any information to the DA about their investigation. Category 2 are 4 letters back and forth between the Norfolk DA and other agencies, wherein the Norfolk DA is complaining about the fact that they're being investigated and asking for the U.S. Attorney to be taken off that federal investigation. And finally, category 3 is 1 letter from DA Morrissey to the new special agent in charge of the FBI asking him to have his agents speak to the state police who are under DA Morrissey's command.
Thinking
To
that
be
they
clear,
would convince them to change
there
their
is no
mind.
confidential grand jury information in those letters. There are no records, orders, and subpoenas relating to any grand jury that should be kept under seal. There are no policy positions being developed or discussed. There is nothing in those motions that's the proper subject of a protective order. And I suspect that is why the U.S. Attorney has no objection to those letters being revealed to the public. That should end this court's inquiry. The Commonwealth has not met the legal standard necessary for the issuance of a protective order, and this issue should be put to bed. The letters are not the proper subject of a protective order. They should be unsealed forthwith. But assume for a moment that this court decided otherwise and issued the protective order sought by the Commonwealth. I ask this court, what good would that do? How effective would that be? The answer is it would not be effective at all. And in many ways, it would be meaningless. I say that, Your Honor, with no disrespect intended. I say that because that's the reality of this situation. Immediately after our last court appearance, as I promised when I last addressed this court, we filed a motion for sanctions against District Attorney Morrissey, including a request that his office be disqualified from continuing to prosecute this case. I expect that motion will be heard on our next court date. And I ask this court to consider what that hearing will look like. That hearing will prominently feature the contents of all of the 8 letters that are at issue here today. The specific content of those letters is one of the grounds that gave rise to our motion for sanctions in the first place. In fact, our motion for sanctions liberally quotes from those letters. And I assume that that is the reason that our motion for sanctions is currently impounded by this court as well. But it is clear from those letters that District Attorney Morrissey is well aware that he's the target of a federal investigation as a result of his conduct in this case. Those letters prove that he knew that, even before the U.S. Attorney ever confirmed that there even was an investigation. And Your Honor, on that score, something very important has come to light just yesterday that directly bears on this issue. The Norfolk DA's office and the Karen Reeve defense team participated in a conference call yesterday with a representative from the U.S. Attorney's office. The U.S. Attorney confirmed during that conference call, confirmed for both parties, that not only has there been a federal investigation of this case, but it is ongoing. It's not over. It continues. The DA.
Okay. So I don't know how often I have to, I'm trying to stay back, but let me just tell you, he is hot and he has every right to be. And this judge going forward at this point, I mean, are they all trying to nail their coffins shut before they're put in them? Because they're burying themselves with their behavior in the public. It's on TV for the world to see. We've all watched the trial. We've all seen it. we've all been just, I mean, if I knew the law, I could just probably write, what, a good 10,000 pages just on reasons that you didn't let pertinent information in. Okay, I think I did enough. Sorry. And I know that I have my thing muted, um, uh, but my attitude is this is how I watch stuff. My family just gets, but here you go.
Had this confirmed for them just yesterday, right from the horse's mouth. That means, Your Honor, that District Attorney Morrissey and his office are targets of a federal investigation. And please consider what that means for the upcoming hearing on our motion for sanctions. The anticipated nature of that hearing bears directly on the ruling that this court will make today on the Commonwealth's motion for a protective order to keep the 8 letters impounded. We have the 8 letters. We've seen them. We've read them. We are using them. The genie cannot be put back in the bottle. Those letters are powerful evidence that we will use to publicly support our motion for sanctions. My client is entitled under the Constitution and the Massachusetts Declaration of Rights to present as effective a defense as she can to these false charges. She's entitled to lawyers who will zealously represent her within the bounds of the law. She is entitled, in short, to have the contents of those letters made plain to this court, both in writing and during public oral argument on our motion for sanctions. And that argument will happen in public, whether this court issues a protective order or not. The Commonwealth is moving for a protective order for these letters after revealing part of what they contain. But the Commonwealth wants to keep the remainder of the letters hidden because those letters contain information that will embarrass District Attorney Morrissey and his office. The letters demonstrate that he's a target of a federal investigation for what his office has done to Karen Reed. So, Your Honor, because the Commonwealth has not met the necessary legal standard for a protective order, and because a protective order would be effectively meaningless here in any case, this court should deny the Commonwealth's motion.
All right, is there a response from the Commonwealth or no?
No, Your Honor.
Okay, all right, so I'll take this under advisement. I do need copies of these letters, so if Mr. McDermott can make copies and then hand them back to the Commonwealth. All right, so the second motion is the Commonwealth's motion for Rule 17 for records.
Did she even act like she cared, guys? I mean, she didn't act like she cared. She was sitting there. Do these people think that Lowley and Morrissey and all them? Well, apparently they did think that they were so overly important that we would have no issue whatsoever when court happened. I'm guessing. But then they were all involved in the Sandra Birchmore case. So let's see if we can embarrass ourselves further. Y'all just keep getting egg on your face. Pretty soon it's going to just.
From Boston Magazine. And I understand there's counsel here from Boston Magazine. If you'd come forward, sir.
Does she not look so friendly and happy right here?
Hi, you can stand at the podium or council table, wherever you're comfortable. In a minute, I'm going to ask you your name and I'm going to hear from you, but I do just want to state that I appreciate that today I did receive a response from Boston Magazine. I received there's a memorandum, there's a limited opposition, there's affidavit, there's a memo. I found all of this helpful. I did have the opportunity to read it a short time before the hearing. But I do appreciate the response, and more importantly, I appreciate you being here. So could you tell me your name, please, sir?
My name is Robert Birchie. I'm from the firm of Claris Law.
Could you spell your last name, please?
Last name is B like boy, E-R-T.
Could you spell your last name, please? Would you spell your last name, please? I mean, I may use improper English all the time, but I don't act like I'm sitting on a throne either.
E-S-C-H-E.
Okay. All right. Could you tell?
I'm Metro Corp, doing business as Boston Magazine, and also the reporter Gretchen Voss.
All right. So there is the Commonwealth filed a Rule 17 motion. You, as a third party or the record holder, have a right to be heard. So I'll hear you.
Thank you, Your Honor. There are really 3 documents at issue, 2 recorded interviews, one 4 hours long, another one 2 hours long, that are largely, almost entirely on the record, were interviews with Ms. Reed in the presence of her counsel.
Can you say almost entirely on the record? Could you explain that, please?
I'm sorry. There are a few
Mercy. Do y'all see? She's like, it's like she's almost fallen all over this attorney. Does she think if she acts really sweet, she'll get her way? I mean, why is she so nice to everybody except the defense? And I can say that after watching the entire trial. It's not my imagination.
interjections by counsel. And there are also a few areas where counsel asked, or Ms. Reed asked, that certain information be kept off the record.
Okay.
So if those were to be produced, we would ask for the opportunity to redact those.
Okay, I understand that. What's the third or the second category, the third records?
The third is a interview with Karen Reed alone at her home between Gretchen Foss and Karen Reed that was not recorded, for which there are handwritten notes. And that interview is entirely off the record, subject to the parties agreeing to put anything on the record afterwards if they wanted to, but they did not. And no statements of Ms. Reed from that interview appear in the article.
Okay.
There's also a fourth category, Your Honor, that just I became aware of last night, which is that there are a limited number of voicemails and texts between the reporter and Ms. Reed that were also considered to be off the record unless otherwise agreed.
Have those been maintained?
They have been maintained.
All right, thank you.
Notice how concerned she is about all the BS being maintained. And what are they hoping that Karen Reed was making errors in her comments? You know, the thing that the thing that I would think that the judge would realize is Karen Reed is not afraid of any true evidence coming out because she didn't do it. There's nothing that's going to prove that she did something she didn't do. But I mean, she's got it right. They went through everything but her sock drawer. And they're trying to get an underwear drawer or something. I guess that's where she keeps her socks because man, they're doing everything they can. And this is just ridiculous. It's ridiculous. Like she said something to the reporter that would make the case, right?
The argument that I'd like to make, Your Honor, really has three parts. First, that the Commonwealth's request is unreasonable under Rule 17A2,
Okay.
because it really is just a fishing expedition. The second is that the documents in question are privileged under the common law privilege that permits a reporter under certain circumstances not to turn over unpublished notes and outtakes, and that's especially so if they're confidential. We are not, to be clear, opposing disclosure of those two interview audio tapes when counsel is present, subject just to the redactions that I previously mentioned. And the third point I want to make is that this case really differs from many others dealing with a reporter's privilege due to the degree of harassment that this reporter has already experienced due to her objective coverage of this case.
Do you hear what he's saying? The reporter is being harassed because of her objective coverage of this case. I'll give you three guesses as to who is making her feel unsafe. The McAlbert side. And I'm going to say this again. You know, it's such a shame that we have a trial supposedly against an alleged killer, which didn't commit the crime. And it's turned into the McAlberts against Karen Reed. It should have been called the McAlberts against Karen Reed. This is not a trial about what happened to Officer John O'Keefe. That's clear. That's so clear. I mean, does anybody else feel that way, or is it just me? It does not feel like this was any trial that I've ever watched in trying to convict a killer. this is trying to say that the McAlberts are right and that Karen Reed is a monster. And it's so far from the truth.
Case.
Can you tell me about that?
I'd be happy to, Your Honor. And she discusses it in her affidavit as well. She has received emails. She has received voicemails. She has received threats to herself and to her children. She has received inappropriate, shall we say, texts with photographs that have been altered.
Have these been to her private accounts or her professional?
To her private accounts, I believe, yes.
Okay.
And and she says, that these are, she's never experienced in her 25 years of reporting anything like this before.
These are
So
your
if Your Honor's
friends,
all right, I'd like
Judge.
to proceed to the Rule 17A2 argument.
Yes, please.
Rule 17A2, as Your Honor well knows, is not supposed to be a discovery tool. It's supposed to be a tool for bringing materials before the court prior to trial for the ease of trial administration. Here, the Commonwealth already has a lot. They've got a long, detailed article setting out, among other things, many statements of the defendant about the facts of this case. And the Commonwealth has said that it plans to introduce those statements and records at trial. But their argument for more is simply that the article is such a goldmine, there must be more.
Exactly.
And that's unlikely, first of all. The article set out the positions of both sides in a very comprehensive and balanced way. You can be sure that if Karen Reed had confessed in her interview with Gretchen Voss, that would have made it into the article.
Yeah, yeah.
This is a fishing expedition because, as this court has already noted in this case, Rule 17 is not supposed to permit a general fishing expedition for evidence not yet obtained.
Yes,
and the extra
exactly.
that the Commonwealth
This
asserts
is
might be
fishing.
found really isn't very applicable. They talk about nonverbal conduct. Well, they're not going to see nonverbal conduct in an audio tape, body language, physical reaction to a question. The same thing, these being only audio tapes, I won't reveal that.
I want to
And there are
analyze
further
Karen
arguments about
Reed.
Rule 17A2 in my papers. With respect to privilege, as far back as 1971, the Supreme Judicial Court said that a court has discretion to prevent excessive or unnecessary interference with the legitimate interests of witnesses, including by too broad of subpoenas. And that was in Re Pappas case, 358 Mass 613, the case that ultimately, when it went to the Supreme Court, became Brandsburg v. Hayes. Now, before the court has discretion to prevent excessive or unnecessary interference with the legitimate interests of witnesses by too broad subpoenas, that's stated in Pappas. And the court may take into account all pertinent circumstances affecting the propriety, purposes, and scope of the inquiry and the pertinence of the probable testimony of the particular witness. And in particular, the Pappas Court said it may be argued that use of newsmen as witnesses is likely to result in unnecessary or burdensome or gratuitous use of their work product, where the testimony of police or other witnesses would suffice. This, if shown, a presiding judge may consider in his or her discretion. Underscoring that point, when the U.S. Supreme Court affirmed Pappas, it did so, quote, subject, of course, to the supervision of the presiding judge as to the propriety, purposes, and scope of the grand jury inquiry and the pertinence of the probable testimony. In fact, in Brandsburg v. Hayes, the Supreme Court made a majority opinion, but it depended on the concurring, to make a majority, it depended on the concurring opinion of Justice Powell, who wrote, if the news person is called upon to give information bearing only a remote and tenuous relationship to the subject of the investigation, or if the news person has some other reason to believe that his testimony implicates confidential relationships without a legitimate need, he will have access to the court on a motion to quash, and an appropriate protective order may be issued. There is no law that subjects the editorial process to private or official examination merely to satisfy curiosity or to serve some general end, such as the public interest. Now, since then, as the case law has developed, in 1980, in the case, in the matter of Walter F. Roach, the Supreme Judicial Court stated that a judge is obliged to consider the effect of compelled disclosure on values that underlie the First Amendment and Article 16 when considering a request to compel information from a reporter or a news organization. They went on in 1991 in the matter of the matter of John Doe grand jury investigation, to say that this balancing requires balancing between A, the public interest in having every person's evidence against B, the public interest in the free flow of information that can be implicated by needless disclosure of sources or confidential information. In that case, Doe.
Oh Lord, we're doing the mic again. I was fixing to say, have y'all noticed that she's not like doing the mic? The other thing is, look at her. Look at how friendly she looks to this attorney. She looks like she's paying attention. I don't remember her ever doing that to the defense, but that's just my observation, my opinion.
Affirmed an order quashing a grand jury subpoena issued to a news reporter in a murder investigation where the information sought had, quote, according to the court, low likelihood of benefit to the grand jury when balanced against the public interest in the dissemination of information. That's CommonWealth against Doe, 410 Mass at 602. There's also the CommonWealth against Bowie case from 1995, affirming a trial court order quashing a subpoena issued to a reporter by defense counsel in a murder case. And those two cases, I'd say, are exactly on point. Now, here, Ms. Voss has to some extent performed her own balancing test. And after considerable discussion and consideration, she decided to waive her privilege as to the two recorded on-the-record interviews that took place where the lawyers were present, except for those sections that were lawyer colloquy or designated to be off the record. But she asserts the privilege firmly against production of the handwritten notes of an unrecorded, off-the-record interview outside the presence of counsel. I'd submit, Your Honor, that her notes of that third interview are unnecessary. She's not an eyewitness to any events in the case. She's provided a detailed article that provides a roadmap to Ms. Reed's statements and is set out in her affidavit. Production under these circumstances really does threaten legitimate interests. Some of those set out in the affidavit of Chris Vogel, the editor of Boston Magazine. Judicial intrusion into the news gathering process, the disadvantage of a journalist appearing to be a research tool of the government, the disincentive to the media to save notes and to interview outtakes if such can be casually compelled, and the burden on journalists' time and resources. And my client would attest to you that already the burden on time and money has been more than they care to bear, although they do understand that under normal circumstances, the Commonwealth is entitled to evidence when there are proper circumstances. All of these interests, along with the harassment campaign against the reporter, disincentivize the media from engaging in objective investigative reporting. So there's a principle that is at issue here, and it's the ability of the press to continue to perform their constitutionally recognized role as the fourth estate. Now, there's additional argument on this, which is recently revised federal criminal guidance that supports the denial of the Commonwealth's request for the off-the-record interview notes or for any unpublished material. The petition for the promulgation of rules, 395 Mass at 172 in 1985, the Supreme Judicial Court said, in cases like this one, where the reporter has no personal knowledge of the events about which he is called to disclose information, it may be appropriate for the trial judge to consider the guidelines of the United States Department of Justice contained in the CFR. And the rule, as revised in 2002 from the Department of Justice, declares that, quote, the use of compulsory legal process to seek information from or records of non-consenting members of the news media constitutes an extraordinary means, not a standard investigatory practice. It goes on to say that the department may not use compulsory process to obtain information from or records of a member of the news media, period. Now, I'm not saying that that is binding on this court, but it is, I think, persuasive from the nation's federal police authorities. So in conclusion, I ask that the court deny the Commonwealth's request as it pertains to the handwritten notes of the off-the-record interview and as it applies to the lawyer colloquy or off-the-record statements in the two audio recorded interviews. Voss and Boston Magazine do not oppose if the court exercises its discretion to allow the remainder of those two taped interviews to come in, since lawyers were present and on the record. And as to the texts and the emails, if any, voicemails, I'm sorry, those being also under a promise of confidentiality, we would ask to withhold.
Has anybody seen her look so
All right.
intently at anyone speaking that wasn't
So is Ms. Voss willing
Commonwealth?
to still provide the
Just
first,
curious.
the 4-hour interview and the 2-hour interview that are on the record? She's still willing to provide those?
Willing to provide the recordings, yes.
Okay, and how long will it take for you to provide those to us?
Well, there will be some redaction
Yeah.
needed. I'm not quite sure how that gets conducted,
Okay.
but within 2 weeks,
Okay.
possibly less if necessary.
All right. All right. I'll hear the Commonwealth, and then I'll give you a chance to be heard again, sir, if you want.
Thank you.
All right, Mr. Lally.
Thank you, Your Honor. Your Honor, the nature or the chilling effect on news gathering the council alludes to in the motion
We
in
didn't
opposition
hear
as
her
well as
go to
an
the
argument,
podium.
Commonwealth
Well,
submitted
this is
is speculative at
on
best.
Zoom.
I refer to the
So
court to
disrespectful.
the decisions that are cited by counsel in the opposition, as well as sort of ancillary to those, the Brandsburg and the Jennings decisions as well. They're federal cases. But essentially what they state is that the state's interest in criminal prosecutions outweighs First Amendment concerns regarding confidentiality, particularly whereas here, the source itself is not confidential. So we're not talking about a confidential source, we're talking about potentially confidential information. But notably, what's cited to our federal cases because there is no reporter privilege in the Commonwealth of Massachusetts. It doesn't exist. What I would submit based on the Commonwealth's motion and submissions that there's not even a hint or a scintilla of a hint of bad faith or harassment by the Commonwealth, nor is this a fishing expedition to cull through a vast array of relevant information. What we're looking for is statements of the defendant. Not asking for statements of the defendant's attorneys or anyone else. Not asking for the reporter's impressions or thoughts or any other things that may be contained within her notes. The statements by the defendant to this person are relevant, they're admissible, and the Commonwealth's request is specifically tailored to just those statements. The timing of the statements the Commonwealth would submit is also instructive and salient in this sense, in that we're not talking about some sort of vacuum where there's the potential future prospect of a criminal prosecution. These are statements that are made while there is an active criminal prosecution ongoing. The defendant is obviously aware of that. For 2 of these 3 interviews, she's present with her attorneys, who presumably know that there is no reporter privilege in the Commonwealth of Massachusetts. And yet she makes these statements voluntarily. She agrees to these interviews voluntarily. She's not compelled in any way to do these interviews. But the fact that these interviews exist and the fact that there are statements by the defendant that specifically pertain to this case makes them relevant, makes them admissible. And that is why the Commonwealth is specifically requesting those particular items.
But he knows she's innocent.
As far as
What
these
difference does it make?
other items for which the record holder has an opposition, the Commonwealth has no issue with the record holder properly redacting or vetting through the content to ensure that the only thing that is provided is what the Commonwealth is seeking, which is just statements of the defendant. Nor does the Commonwealth have any issue with any sort of in-camera review by the court as far as deeming whether or not any of those statements as provided are relevant. But the Commonwealth is entitled to these, has met its burden under Rule 17, would ask that the motion be allowed.
So in the balancing test that the law says I have to do, shouldn't I consider the danger or personal risk to Ms. Voss, considering what's already occurred to her?
So, and I'm not in any way trying to minimize that, and I would submit that yes, I think that is something that the court needs to consider in its balancing test. However, I think what the case law also says is that those types of concerns yield to a criminal prosecution in this case. And in part, again, just based on the limited specific scope of what the Commonwealth is requesting, again, I understand Ms. Voss's concerns when it may come to her notations as they apply to her impressions or her thoughts or things that she observed or whatever the case might be, as to whatever her notes contain. But the only thing that the Commonwealth is seeking from those notes is statements by the defendant. That's it. So as far as any other things that may be contained within her notes, Commonwealth's not interested in that.
Whoops. All right, let me just ask you, if a reporter is writing notes, how could that be admissible into anything? Because she could write anything down. She could make a mistake, she could throw things in. I mean, but the bottom line is, why is he doing this? Why is he knows she's innocent? He's wasting time. I don't know. It's ridiculous, Lally. Absolutely ridiculous.
Those, not seeking those, not asking the court to order those in any way, shape, or form. And again, as it pertains to any of those items, the Commonwealth would suggest that in this case, I think an in-camera review by the court would be appropriate based on whatever is submitted, particularly as it pertains to that. Sir, I don't think there's as much of a concern, and there's no real objection that I can surmise as to the first 2 recorded interviews. But as it pertains to the notes, I think an in-camera review would be appropriate.
She's trying so hard.
A couple of things, Your Honor, very briefly.
Sure.
I'm not sure that the Commonwealth heard what I said because Ms. Voss does not oppose the release of the two interviews, say that the
Commonwealth never
off-the-record
hears
portions
us
of the
out.
lawyer.
I think he's talking about the third interview.
Yes, but I'd also refer to any part of the first two interviews deemed off the record that would contain any statements by the defendant. So I don't know what the off the
he's
record
talking about everything.
portions contain, but if they contain statements by the defendant, the Commonwealth will
Oh,
be
yeah.
speaking those as well.
Dally wants it
Well,
all.
that gets
He
to
wants it
the
all.
next point, really, the distinction between confidential sources and confidential information. And I submit that that's a distinction without a difference. The same.
But is there any case law that supports that?
I don't have it at the top of my head, Your Honor, but I do believe.
Please feel free to provide it.
All right.
Look at it.
Finally, I want to make clear the Boston Magazine and Ms. Voss are not arguing that the Commonwealth is acting in bad faith. In fact, I appreciate the way in which they narrowly put their subpoena in terms of only wanting statements of Ms. Reed and not of anyone else, not from counsel and not from other things. I do take issue with the notion that the Massachusetts law doesn't recognize the common law privilege. They do. They recognize an evolving privilege that's really flexible enough to take in the particular facts of every case. And the cases are uniform in saying that the judge has a duty in the civil side to enforce Rule 26C with particular rigor, and on the criminal side as well. The question of harassment comes up as part of that test. And it's true. We're not saying that the Commonwealth has harassed Ms. Voss, but she has, in the unique circumstances of this case, suffered and will continue to suffer harassment to the extent that her role becomes large. And ultimately, Your Honor, there's a lot there, and we're not saying the Commonwealth is overreaching, and we're not saying that the Commonwealth is in bad faith, but we are saying that the Commonwealth is asking for too much.
Okay. Thank
As
you very much.
usual.
So you say it'll take you 2 weeks to get those first two redacted
Oh, she
and
just thinks
sent
there's
in.
something there.
And if you want to respond with at least that case, so I'll take 2 weeks then to decide this. So the sooner you can get me anything else you want to get me, I am concerned about the safety of the reporter.
Yeah, I bet you
She
are.
shouldn't have to suffer harassment or
Should
any
even be
danger as a
more
result of
concerned
this.
now that you know how
All right.
crooked
So-
every last one
February
of the
1st,
people
which is
in
2
the
weeks from
DA's
today. Is that
office
doable?
is.
That's doable.
Okay. All right. Thank you. So, Ms. Giannetti, we need to get a date for the remaining two motions that were filed by the defendant, the motion to dismiss and the motion to disqualify the district attorney's office and sanctions. All right. So as you probably know, we're in the middle of a trial that's going to go a few weeks.
Yeah, you say that every chance you get. As you know, even though everything tells you not to do
So
it,
can you
right?
suggest a date?
I
Just
can't.
wait. Let
How
the
about-
FBI finish.
May I interject, Your Honor, with regard to a date?
Please do.
I know that our final pretrial is February 15. Our request will be that-
February 15th? I thought it was February 26th.
We have two.
Okay.
We have February 15th and February 26th.
Okay.
So you're both right.
Well, that actually fits in with what I was going to ask, because our request would be for the motion to dismiss and the motion for sanctions to be heard on February 15. I'll tell you why, Your Honor. One thing that I did not mention regarding the conference call that we had yesterday with the U.S. Attorney is that they notified both parties that they'll be going through the TUI process to take the extraordinary step of releasing information from their investigation to the parties in this case that directly bears on our case. This is almost unheard of. There's an active investigation, and they're going to release information to both parties because in good conscience, they can't allow this case to go to trial.
Did they give you a date, Ms. Giannetti?
They did not, but they did say that it could take a week or two, I believe, to go through the TUI process. My expectation is we'd probably get this information sometime in early February. And I don't want to argue, particularly the motion for sanctions, without seeing the evidence that's out there, because I believe that evidence
I'm so sorry, guys. I thought somebody was coming in my room. Matter of fact, I think they did open the door, but they didn't stop. So my apologies. And I could have stopped her. Oh, Lord, I'll figure it out.
will impact our argument.
All right. Does that date work for the Commonwealth for that purpose?
I'm sorry, the 15th?
Yes.
That should be fine.
Jim, is that at 2 o'clock?
It is, Said 9 o'clock.
All right, assuming we're not on trial, it'll be at 9 o'clock. If we're still on trial, it will be at 2.
That's fine.
Your Honor, the only issue there is that I do have a trial before Your Honor that's scheduled for February 13th. So
Oh, but this one
Right,
takes
that's
precedence of
the case that I expect we'll be on trial for. And if that's the case,
Oh.
we have to finish that. We've got a very busy trial schedule.
Yeah,
So if we're on trial, we'll see you at 2 o'clock. All right, so stay in touch with Mr. McDermott. All right, is that it for today then?
that's it for the CommonWealth. Thank you, Your Honor.
You all set, Mr. Yannetti?
Yes, Your Honor, thank you.
Okay. All right, and Mr. Birchie, I appreciate you being here, sir. All right, hearing's over. Jim?
Thank you. February
All right, that was it. That was it. So that's all I wanted to bring. I love Karen smiling right there, but if I'd have watched this if I would have watched any of this pre-trial, then I mean, obviously my mind would have been made up because watching them try to, I've never seen anybody try so hard to keep out evidence that could help the defendant. And it's true. It's what's going on. But they want to cover everything up. And she's like, oh well, when are they going to come forward with a trial? Well, you know what's really good? The fact that these people refused to step down. They tried to railroad Karen Reed while all this was going on. And it is fixing to blow the smithereens out of these people, blow them out the water. I don't know how long, but it can't get any. Well, let me just say, it can get a lot worse. So, Morrissey, weren't they the ones that investigated Sandra Birchmore? And see, I know, and I have to go back and listen because my memory is not quite like the rest of you guys. Hell, believe me, my memory is not like it was in January. Lately, I just can almost cry because it's like things I don't remember. But let's just say that while I'm having a conversation, I can forget what I'm talking about too, and that's kind of embarrassing when I'm doing a video. But I just think that I'm just kind of scatterbrained. I don't know. I'm just whatever. But because I couldn't talk about the FBI investigation in the court, I know that in the pretrial motions, Lally spoke about them. And Lally, if I'm not mistaken, continually made reference to the fact, he led it to, or he tried to make people believe that this was all due to Karen Reed's team or Karen Reed or somebody going and basically whining to the FBI that they weren't be treating fair. No, Karen Reed is blessed. She's blessed. God's looking out for her. It's also looking out for Lucky, which I think we all know that had Karen Reed not woken up that day, they were going to try to blame Lucky because that's the only other thing that could possibly have happened. There's no way that they could have just said, "Oh, Karen Reed just brought him and dropped him off, and he just died out front." I mean, that wouldn't work. So that had to have been the plan. Sadly, but yet thankfully, there's so many things all rolled into one thing. So it's sad, but thankful that she has the means to fight this. Lucky probably would have been destroyed and he probably would have been put in prison and no one could have helped him. That's strictly my opinion. And that's just me trying to come up with they put him out there. What did they expect? The one question that I would really like to ask Karen one day is, I bet she wish she would have just stayed asleep. I mean, don't y'all think so? It'd be different if she would have found him and he would have survived, but due to the fact that it went in this manner, I bet she wished she would have just stayed asleep. This horrendous nightmare because she woke up, he wasn't home, she panicked and wanted to find him. That's what caused all this. And nobody seems to care that she was the one that was she you could hear her. I mean, her screaming should have woken up the Alberts. Of course, we all know they weren't asleep. So I don't really know what more to say about what they're doing, except that it's so obvious that they're doing everything except the right thing. And I don't get it. I don't understand why a judge would want to be taking this kind of risk. She's got to know they're crooked. She's got to know. Well, maybe they got some on her too. Question is, how high up does this all go? Who was the first one to sell their soul to the devil, and how did it go from there? Because this is a very big thing. And I think I said it yesterday. If I didn't, I'm going to say it today because my husband looked at me like I'm crazy. But I said, because of Sandra Birchmore, they were already investigating all the main parties in the Karen Reed trial. That's why they got involved in the Karen Reed trial, because they were already investigating these men for what they had already done, and then they go out and they're trying to frame her. And FBI's like, whoa, no, see, we don't operate like that. The FBI, thank goodness, they do have morals, and I'm sure that if they find a bad FBI guy, they get them out really quick, instead of like Canton, Mass, where they just keep on recruiting people that the bad guys can turn their way. That's my assumption. But this was actually February. So I'm going to go back because I believe this was February of 2024. And I'm going to go back and see if I can find out some different things. I'm sorry, January the 18th. Why I'm reading February down here on my notes. So January the 18th of 2024. But I still have to go back to May of 2023. I know that I'm a little bit out of order. And the only thing is, with everything happening and the fact that I'd already read the letters from the FBI, I wanted to go ahead and bring this so that it's close enough to that and it's not all scattered out. Although I want to do them in order, there are things that just will drive me crazy on a certain topic. And I just decided, if I'm going to do that, I'm going to figure out how to just go ahead and do it all at the same time. So hopefully I'll figure out what I'm doing. I thank you all for stopping by. I hope you're having a great weekend. To anybody that's going to be going out and doing Karen Reed standouts, I wish I lived up in the area. I would join you. And for me to say that is, I don't do crowds. So, but I would stand out there for her. I would stand out there for her, for Canton, and I would stand up against the evil and the bad. I think I was born fighting the evil, actually. I think it's something that was given to me to survive. So with that, I'm going to say goodbye, and I hope that everybody has a good time. I have not decided what my next thing is, when my next thing is, if I'll be live when if I'll be sitting in the audience at all when this is going on, or if I'll be busy digging into something else, because I've got notes everywhere. I'm trying to get them all organized, and I'm trying to stop using pen and paper and use the computer and have my things ready so that I don't. I get so frustrated, and then when I don't even go back and watch the videos that I've done. So I'd probably be really embarrassed. But anyway, it is what it is. No, I doubt I'd be embarrassed. I'm old. Live chat replay was turned off this video. And just remember, please, as we're thinking about it, everybody needs to remember that attorney was arguing for a journalist. The journalist was being harassed, and as we can tell from everything that we've seen, supporters of Karen Reed cause no harm. They don't threaten anybody. They don't try to hurt anybody. None of them will kill turtles. None of them will try to destroy your yard. And in that one was dangerous because it could have hurt children in the neighborhood. So that one could have harmed many people. But they don't care to find out who did it. They don't care to find out because they already know. So I don't know. It's about coffee times. Let me go get my coffee and I'll see you guys later. And I hope you have a good night, day. Tomorrow's Sunday, I'm guessing, right? Today's Saturday? No, wait. There's today Sunday. Tomorrow's Monday. Yeah, I think. See, I don't ever keep up with the days either. Bye.